deposition that the claims with regard to Century are really just derivative based on a theory of agency. Mr.
A
Skinner
theory of what?
Agency.
Okay.
Basically, that Century was just one of the tools used by the HOA to do the things that he outlines in his complaint. So they're kind of along for the ride, more or less. It's important to note Century has no contract with Mr. Skinner personally. They have no other duties other than what anybody owes to anybody. So Century is just a contracted management company with the Homeowners Association. The actions that Mr. Skinner alleged seem to begin about 2015 with regard to a board election where Mr. Skinner, I believe, was voted out in favor of some new board members. Prior to that, Mr. Skinner, I believe, served as the president or the president of the HOA for some time. But he has since that time routinely disapproved of the actions of the association, has incorporated those into the 25 counts. Almost every single count, as you mentioned, we contend represent allegations of harm to the membership at large. Mr. Skinner admits that many of his allegations are injuries to the corporation or the membership and are not unique to him. I've outlined that pretty extensively in my brief. I can go through those if you like, but if they're all
no, I don't. I mean, you're welcome to. I don't feel the need for that level of detail because it's set forth in your brief. I've got what you wrote. I've got what Mr. Skinner wrote, and I'll certainly be guided by that. So I don't think you need to repeat it here.
Okay, great. So Mr. Skinner's complaints fall into, I would say, three general categories: those that are election related, those that are financially related, and those that are rule related. Basically, he takes issue with the procedures of certain elections, with the decisions for certain expenditures, and the procedure which the association and its board followed to make certain decisions. But these counts generally speak to the way the association has been run, and they're all based on Mr. Skinner's interpretation of the governing documents. So on top of that, we also have the only counts that are not included in those broad categories are ones in count 11 for punitive damages and count 25 for recovery of expenses under OCGA 13611. Naturally, those cannot be recoverable if the other counts are found to be unsustainable in my motion. So I'll briefly touch on those. But in any event, this is a motion for summary judgment. Mr. Skinner, in terms of my motion, I have the burden to show that there's no genuine issue of material fact, and he has the burden, vice versa, for his motion. So in this particular situation, yeah, I make several main arguments. The derivative action is very important. In Georgia, the membership of a domestic corporation may bring a legal action as a representative of the corporation against its board of directors to protect the corporation and its assets. It's a derivative proceeding. A derivative proceeding is defined as a civil suit to defend those rights belonging to the shareholders and corporation as a whole, and the code section on that is 142740. There are several statutory conditions precedent to bringing such an action. The person must be a shareholder of the corporation at the time of the alleged act, which I don't think there's any issue with.
Meaning just when you say there's no issue, meaning you are not challenging Mr. Skinner's status as, we'll call it a shareholder, but you mentioned at the outset, he's one of 191 people who could bring a derivative suit.
Yeah, one of 193, yes. We're not,
93.
no issue with that.
Okay.
But the member must fairly and accurately represent the interests of the corporation in enforcing its rights. This is compared to a shareholder's right to a direct action, which I believe Mr. Skinner's response was that he has unique injury and he can sustain a direct action. But this can only be sustained if the shareholder can prevail or can show an injury or breach of duty that did not belong to the corporation in proving that damage. So the Supreme Court says to set out an individual action, direct action, the plaintiff must allege either an injury which is separate and distinct from that suffered by other shareholders, or a wrong involving a contractual right of a shareholder which exists independently of any right of the corporation. So when we're talking about this, and I don't believe Mr. Skinner will dispute it, there's no special contractual relationship the HOA or Century has with him. He's relying on the governing documents of the HOA to make these arguments.
That apply to everyone, all 193.
Right. Another requirement to bringing a derivative suit, so going back to those procedural requirements, Mr. Skinner would have been required to make a written demand made upon the corporation to take suitable action on the grievances. The demand must stay open for 90 days before suit's filed unless it's rejected earlier by the corporation, or unless irreparable harm to the corporation would result. So essentially, it would look more like a temporary injunctive relief, some emergency injunctive relief standard, basically. So the case law is pretty clear, though, that failing to comply with the ante-litem notice of 14.3.742 is subjects the case to immediate dismissal. I cite the case of Dunn versus Cicerelli in my brief. That stands for that, and a few other things, actually. With regard to this distinction, Mr. Skinner, in his deposition, I went as methodically as I could through his extensive complaint, and he admitted that he agreed that the injuries described in his complaint are shared by the corporate membership and not specific to him. As you can see, all
This
those
would be for all of, we'll call them the substantive counts, so not the attorney's fees don't apply to him, but the attorney's fees count or the punitive damages count. You'd say for all the other counts except for count 5.
Right. That's right.
Okay.
For the lawn, for the landscaping fund. But all of those, he admits in his deposition, are not specific to him and are really grievances as the corporate membership has as a whole. So going a step further, Mr. Skinner testified that nearly all of the money damages he's seeking in the case should be paid back to the corporation itself and its membership. There was examples I provide in the brief, but that appearance again doubles down on the fact that this is a derivative suit that's being brought in a direct fashion. So Mr. Skinner, as commendable as his efforts are, he's bringing these grievances by a direct action, which is simply just inappropriate. Even things like the mailbox replacement, he agreed that he actually benefited from a mailbox replacement, but complained that because there were undeveloped lots in the community that did not have mailboxes, not all members benefited from that expenditure. So he's essentially arguing that my grievance with the mailbox replacement is not necessarily just for my mailbox, it's for lots that didn't even have a mailbox on them, but they benefit. So again, this is intertwined with all of his neighbors, really. Let's see. I'm trying not to rehash too much we've already talked about. So the Dunn versus Cicerelli case that I mentioned in the brief involves a challenge to voting procedures, which is very important to Mr. Skinner, and it's numbered in its complaint. I think it's 115, 16, and 22 of the counts specific to elections. In that case, it was a board member that wasn't present for a vote. The other 2 board members appointed one of them president. Essentially, there was an election procedure that the absent board member took issue with. The court in that case lays out all the fundamental principles of derivative action. It stated that the primary purpose is to avoid a multiplicity of lawsuits. It seems Mr. Skinner has brought a few supporters with him today. So instead of having every homeowner bring many lawsuits for the exact same thing, they boil them into this derivative lawsuit type of statutory scheme. So that's the main purpose. The court then says that they look to the nature of the wrong alleged and not the pleader's description. That's important. So just because Mr. Skinner says in his response, well, it certainly the election affects me, that's fine. And it very well may. But the problem is that election procedure applies to all. It's a grievance for all. So they concluded that the right to fair and reasonable election procedures is a benefit to all members, and interference with elections does not constitute a separate and distinct injury. There's several cases that are directly on that say that election variability, except in a case where someone's vote was, shredded in the bin or something like that, not following voting procedure, that's derivative. It's pretty clear. And Mr. Skinner, I mean, he doesn't deny that in his deposition either. So we also have to look at the procedural requirements. We're laying out that distinction between direct and derivative. Setting aside all of the issues with the mere fact that this was presented as an individual direct action, even to bring a derivative action properly, he can't meet those requirements either. He's only one of 193 lots. OCGA 14.3.741 says a derivative proceeding may be brought either by any director or by a member or members comprising 5% of the voting power, or 50 members, whichever is less. By my math, that means Mr. Skinner only possesses 0.5% of the total voting power. So even if he wanted to bring a derivative action, he couldn't. He doesn't have enough voting power to do that. I also make some points in my brief about Mr. Skinner being a fair and adequate representative of the interests of the membership, because there's some allegations he makes in his complaint that are antagonistic. So 14.3.741 subparagraph 2 talks about this fair and adequate representation of the membership and bringing derivative action. So basically, this has been interpreted to mean that the individual can't be antagonistic to the corporation itself and cannot be, and if somebody does that, they can't be a fair and adequate representative of the interest. In this lawsuit, he has brought a claim for punitive damages. He's essentially, and this gets into somewhat of a circular argument, but Mr. Skinner is bringing a punitive damages claim against the association, but he doesn't want the damages paid to him. He wants them paid to the association. An association can't pay itself or punish itself. It doesn't even make sense. But wanting to punish the membership at large is an issue, because he said in his deposition on page 98 that to come up with the money to pay a punitive damage award, there would have to be a special assessment on the members. That's certainly antagonistic. So that issue is a little bit of an anomaly in this, in that the punitive damages claim just doesn't make much sense at all, but it shows that there's an antagonistic undertone to some of these arguments. Mr. Skinner is also claiming this court should disregard the election results that have happened since 2015. Now, there were a few years in there between the 2015 election and now where no quorum was established. But I believe there was a recent election for the board. And according to Mr. Skinner, the court is to just disregard those election results just by operation of logic, is what I believe he said on page 40 and 41 of his deposition. So the voting members that wanted that should just be disregarded. I believe that to be antagonistic as well.
When you say there wasn't a quorum, meaning when it was time to vote for a board, there were not enough votes present to make that an official vote? Or are you saying that there was a board, but not enough people would show up on that board to conduct business?
No, there weren't enough people to show up and vote at the annual meeting. That's my understanding.
And so some board may have been selected, but there is an argument to be made that that wasn't a valid election or selection of that board because you didn't have enough votes present.
Yeah, there's really nothing else to do. If you don't have enough to seat a new board, there's really nothing else corporations left to do at that point.
But then your final point on that was, more recently, your understanding is there was an election where there was a quorum. And so regardless of whether there were some interim years with issues in terms of how the board was selected, the present board does not suffer from that alleged defect.
Right. So Mr. Skinner admitted in his deposition, none of the board members that were serving all the way back in that 2015 election that he talks about, none of them are still on the board now. And even if there has been a vote with a quorum recently. So that's really kind of the main point. And Mr. Skinner said that, and I asked him about that. I said, well, if there's been an election, so what about that? He says, well, everything after 2015 is invalid anyway. And that's just by operation of his understanding of the logical solution here.
Okay.
But I feel that's antagonistic. It disregards a properly seated quorum and a properly seated board that was voted. But the anti-litem notice is an issue. So as I mentioned in Dunn versus Cicerelli, they specifically held that when the procedures of 14.3.742 are not followed, it's reversible error not to grant summary judgment in favor of defendants. That's statutory black letter law. You have to serve an anti-litem notice and allow the 90 days to expire. So I believe in Mr. Skinner's response, he said he wasn't required to serve an anti-litem notice because he wasn't suing the government. But I think that's just based on a misunderstanding, or you have to serve anti-litem notices on governments as well, but you have to serve them on corporations as a shareholder if you're bringing an action. So one last kind of issue with regard to the procedural requirements, Mr. Skinner has brought this lawsuit pro se. If he were to even bring a derivative action, he couldn't, because he would be suing in the name of the corporation. A corporation can't represent itself. That's an legal that's an entity that's created by law only. So it has to be represented by counsel, which has not occurred. And I cited a case to that, Leventhal versus Post Properties. It's in my brief. But I believe that it's pretty clear that with the exception of count 5, and we're talking about entirely a derivative lawsuit that's brought in the wrong form. And I believe this all subjects him to dismissal. But I'll get back to count 5 in a minute. So setting aside all of the derivative action arguments, yes, there are statute of limitations issues. OCGA section 9329 lays out the statute of limitations for covenant violations. There's really two parts to that rule. The first one is it's principally 2 years from the action accruing, with the only exception being a failure to pay fines or fees on an assessment. So if somebody gets an assessment on a lawn violation, for instance, you have a 4-year statute on that. You have a 2-year on every other violation of restricted covenant. In the complaint, counts 1, 15, 16, 22, and 24 talks about the election in 2015. His lawsuit was not filed until February 4th of 2020, so we're well outside the 2-year statute of limitations on that. And the breaching of the governing documents generally in counts 2 and 17 talk about, that's the maintenance on the 2 vacant lots that he discusses. That occurred in 2016. Again, we're 2 years out of, we're 4 or 5 years from that ever occurring. So we're outside the statute. So I think counts 1, 2, 15, 16, 17, 22, and 24 should be dismissed as time barred anyway. With regard to the declaratory judgment requests, these are buried throughout the complaint. I'm not sure if the intent as kind of a subset of the relief sought for each, but just to be as liberal as I can in construing his pleading. A majority of the counts ask for a declaratory judgment affirming that the association violated a declaration, or to label something the association did as improper that happened in the past. So a declaratory judgment may not be granted in the absence of a justiciable controversy. The plaintiff must show facts and circumstances whereby they would be in a position of uncertainty and insecurity because of dispute, which would affect their ability to make a future action or take a future action without direction. They're basically in a position of peril. They don't know how to proceed because they don't know what their legal standing is with respect to something or some action. So declaratory judgment may not be used as a mechanism to elicit an advisory opinion from the court. or to render judgment on some sort of future possibility. It has to be something more concrete than that. This case does not present much factually in the way of Mr. Skinner being uncertain of really anything. I asked him with respect to every count talking about declaratory judgment, what his level of uncertainty was, and whether he doesn't know how to proceed on certain issues. He routinely affirmed that he is not uncertain as to his reading of the government documents. He is not uncertain as to the violation he alleges. He's not uncertain as to the facts that support that argument. So essentially, he's asking the court to simply just affirm what he's saying about violation of events that happened in the past. So because these requests are clearly improper, those go to counts 1, 2, 6, 7, 8, 9, 13, 14, 15, 16, 17, 18, 19, 20, and 24. So any declaratory judgment cited in his complaint, especially in those counts, should be dismissed for those reasons. Now, count 5, let's turn back to count 5, this $50 lawn fine. So count 5 arises from a $50 yard maintenance fine that was assessed because his bushes were growing out of control. So we talked about it in his deposition, and Mr. Skinner doesn't even dispute that his bushes were getting out of control. And otherwise, the violation itself was valid. He just takes issue that the notice he was sent didn't have a date printed on. So I believe his thinking on that is there is a 10-day period under the rules to ask for reconsideration of an assessment. And because there's no date on the letter itself, he doesn't know when that 10 days is, and therefore it's valid, and that's it. So he included that in his lawsuit, but since the pendency of the lawsuit, he paid it. He says he paid it because he didn't want to lose any voting rights for unpaid assessments. So the presumption in Georgia is that all payments are voluntary. So that has to be rebutted. That's a very old fundamental rule. The proposition is so ingrained in Georgia law that voluntary payment is not even a defense. Rather, a party seeking a recovery of a payment has the burden of showing the voluntary payment doctrine does not apply. And I cite a few cases in my brief on that. The voluntary payment doctrine is also codified at 13.113. So that's code section again reiterates payments are deemed voluntary and cannot be recovered unless made under an urgent and immediate necessity. The statute even goes on to specify that even filing a protest at the time of payment does not change the rule. And that where all facts are known and there's no evidence of artifice, deception, or fraud in eliciting that payment, it will still be deemed voluntary. So I understand Mr. Skinner is going to say, I wanted to be able to vote in the upcoming election, didn't want there to be an issue with that. I paid the $50 fine. So regardless of whether or not he feels that fine was valid or not, he was simply just following the rules. There was no undue duress. The association didn't come down on him and commit fraud or deception, deceiving and eliciting that payment. He was, in fact, I don't think the board or any of the members specifically asked him to do that. He did it on his own. So I find it kind of interesting. Mr. Skinner has spent such an extraordinary amount of time and effort in explaining how others in the association do not follow the rules, but he doesn't believe he's responsible for paying a yard maintenance assessment that he even admits was justified in the first place. Simply that it didn't have a date on the notice itself. No other issue in that. He paid that. Voluntary payment doctrine bars it. So there's no evidence that the association tricked him into doing that. So I think that count 5 is subject to dismissal for that. Now, there's another argument I addressed that you didn't bring up in the beginning. I want to touch on. Plaintiff has alleged trespass to his property from the mailbox replacement.
And what count is that?
Oh, let's see.
It's number 8. I found it.
You were quicker than me.
Unless there's more than one, I mean, a 25 count. So if there's another trespass in there,
I don't think so. Yeah, count 8. I mean, theft by taking is, it's a trespass on personal property, but yeah, I think that's it. So the issue with the trespass is this. As I mentioned in the brief, in the derivative section, Mr. Skinner agrees that the mailbox replacement was a claim common to all members of the association. And the basis of that claim is that the association violated its rules in making that expenditure. Because he brings up the points that it didn't benefit all the members because there were some undeveloped lots that didn't have mailboxes on them yet. They didn't benefit from it.
where do you know, Mr. Moore, where the mailboxes were? Because plenty of people's mailboxes are actually on an easement that is city property and not private property. So I'm curious if these were all mailboxes affixed to the side of the house, in which case you are in the curtilage of the house, or if they're mailboxes right there on the street, which I don't know that it is even right to say that it involves a trespass, but I don't need to work through that.
I do know the mailboxes are down by the street. I have not investigated whether it's subject to any easement.
Okay.
But certainly something to take into consideration. But with regard to the trespass and the issues with derivative claim to begin with, he essentially gives consent for the agents of the association to enter his property and replace the mailbox. This is shown when we talked about it in his deposition. This is on page 79. He admits he received the notice about mailbox replacement. He admits that there was a notice in there asking him to return the enclosed form if he did not consent to having his mailbox replaced. He understood on page 80, he understood that by not sending the form back, it would result in someone coming onto his property and replacing the mailbox. And he admits that with all of that knowledge, he never sent the form back, did not otherwise instruct anyone not to come on his property or replace the mailbox. He just essentially got the notice, read it, and didn't do anything with it. His complaint's not even seeking money damages for the alleged trespass, but it is simply asking the court to affirm that a trespass took place. Again, going back to those declaratory judgment issues I raised a moment ago. But I believe that consent's an absolute defense to trespass. The association saying, in furtherance of the goal of helping the aesthetic of this community, we need to get our mailboxes in some sort of uniformity. Yeah, I understand there were several in the neighborhood that were in disrepair. And I think there was even problems with mail delivery at certain addresses in the neighborhood. The association made the decision to pay for these mailbox replacements, sent notices out. Mr. Skinner got the notice, knew that if he didn't send it back or disputed otherwise, they were going to come do this. They came and they did it just like he expected them to. So I believe that's a defense to his trespass. I won't spend too much time on punitive damages. As I mentioned earlier.
You don't need to spend any time on that.
Okay. All right. So that's the main basis of my summary judgment.
Okay. Well, why don't I hear from Mr. Skinner then in response to your arguments in favor of your motion, and to your point, Mr. Moore, then we'll pivot and Mr. Skinner can present his arguments in favor of his motion, and you can respond to those. So Mr. Skinner, I am interested now in hearing what you want to share beyond what's already in your brief, because I've got that, that is in response to the arguments that Mr. Moore has advanced in favor of his motion for summary judgment.
Okay. So first, Your Honor, I'd like to start off by...
We can't hear him.
There we go. You should be able to hear him now.
So, Your Honor, first I would like to start off by addressing some of the defendant's statement of facts. Let's see. So, Attorney Moore, continually asserts that I made no demand prior to filing this suit. As a homeowner, I have sent numerous emails talk to board members, phone calls, to address my concerns with the associations not following the rules. And unfortunately, that never resulted in the HOA following the rules. So that addresses no demand prior to filing the suit.
Well, not necessarily. Tell me what you believe constituted your formal demand on the homeowners association as to, it's one thing for you to have written an email to a board member saying, why'd you change my mailbox? And maybe you sent something like that. Are you saying, and can you show me a written communication, not a phone call, but a written communication that would have been effectively to the homeowners association saying, I'm going to bring suit on behalf of the homeowners because of X and Y and Z?
So I guess you could say the key event to me following this lawsuit was the removal of the mailboxes. So essentially we received communication saying, hey, that this is going to take place. In response to that, I requested the meeting minutes, board minutes, and references in our governing documents that supported this action. And the response to that ultimately was receiving a letter in the mail directly addressed to me stating that the HOA had the authority to perform maintenance on lots in the community. But in actuality, in our declaration of covenants and restrictions, that's not the case.
Okay. My question is, do you have a copy of something you sent in writing to the HOA, not asking for documents, because that's what you just told me, that you sent, hey, I want to know your authority for doing this. Show me this, show me this, show me this. All fair inquiries. They chose not to respond to that. That's not saying I'm about to sue on behalf of all the homeowners because of X and Y and Z. That's what I'm asking for. Do you have something like that? Or are you arguing, look, I had some back and forth with the homeowners association. They had to know I was upset about the mailbox situation. And that may be what you're saying, Judge, that's what I got. And then I'll need to decide, does that constitute anti-litem notice? But there are specific requirements. You're saying, Mr. Moore got it wrong. I did alert the board that I was going to, hold on, I have to mute someone here. I did alert the board that I was planning on bringing legal action against the board on behalf of all homeowners concerning, I mean, it would need to be concerning all these things. If your anti-litem notice was limited to the mailboxes, then you may actually be in a position to continue to pursue claims about the mailboxes in your current complaint. But you would have needed to give the defendants this notice as to each claim you wanted to bring. It wouldn't be enough to say, I'm mad about the mailboxes and I'm going to sue you on behalf of all the homeowners. And then you bring in all these other claims about the elections and expenditures and this and that. So I want you to guide me to what you think constitutes your anti-litem notice.
Okay, so to answer your the first part of your question, no, I never explicitly stated that I was going to file a suit. However, I do believe that I made the suitable demand as to, hey, provide your reference, for this authority for the HOA.
Okay, got it. Keep going.
All right. Let's see. Next, I'd like to discuss, Attorney Moore continually asserts that all injuries essentially except the $50 violation notice was shared by the corporation. That's not the case. Specifically here, my direct injuries are the removal of my personal mailbox, the letter that I received in the mail that was addressed to me personally, misrepresenting the Declaration of Covenants and Restrictions, the denial.
Wait, how is that an injury to you?
Because it essentially is fraud. It's presenting to me that they have authority to do something that they don't actually have to do.
What about your mailbox situation is unique in the neighborhood? Did they do something extra bad to your mailbox, or was what happened to your mailbox the very same thing that happened to Fred Jones, who lives 2 houses down?
So that's a point of contention here. So the mailboxes were not replaced throughout the entire subdivision. The mailboxes were only replaced throughout phase 1 of the subdivision.
Okay, so let's limit it to phase 1. Presumably Fred Jones, 2 doors down, is also in phase 1. So is there something different that happened to his mailbox such that your injury is unique?
No,
But if I lived in phase 2, I didn't have the same injury you had because my mailbox either didn't exist because it hadn't been built yet, or they left it alone. They didn't mess with phase 2 mailboxes.
correct, Your Honor.
How big are is phase 1 2 houses, or we've got almost 200 houses?
Phase 1 is roughly, it's like 75 houses,
75 houses. So is it sort of 3 phases or how many?
2 phases.
Oh, so phase 1 smaller, phase 2 bigger.
Yes,
Um,
and phase 2 hasn't been developed yet.
it's undeveloped.
Correct, sir.
So there are 193 lots, only 75 of which are developed.
Yes.
It's a lot of undeveloped lots. Are they clear cut? Are they just like plumbing stubs sitting up, or is it lots and lots of trees?
At this point, they do have the plumbing studs. The original declarant went out of business.
Okay. So if I wanted to move to Villages at Oakshire right now, I'd need to move into one of the phase 1 units because someone was selling because they're not built in phase 2.
Yes, Your Honor. And
Okay. So the reason why phase 2 is treated differently with the mailboxes is they didn't have any because there were no houses there.
are you asking me that question?
Yeah, I'm asking, so the reason why you're different, hey, if you were over in phase 2, you didn't suffer the same injury that Mr. Skinner did in phase 1. But really, there's no one in phase 2 is unoccupied.
Correct.
Okay.
However, assessments are still assessed to phase 2.
Who pays those?
The lot owners.
So people own land in phase 2, there's just no houses on them?
Correct, sir.
Are all the lots, we're sort of going beyond the scope. I'm just trying to understand. I've never been here. Are all of the 120-ish lots in phase 2 owned,
Yes,
but no houses on them?
not yet.
Are they owned by 120 different people, or it's one big developer and maybe now a new developer because you said someone went out of business?
The primary owner currently is in between Silverstone Communities and DR Hort.
Okay.
And I might be misspeaking. I'm not sure if
I'm not holding you to any of this because it's helping me understand. Mr. Moore kept saying, well, Mr. Skinner's only one of 193 votes. Are there really 193 votes because the undeveloped lot owners get to vote? Or are there 75 votes because there are only 75 functional households in the neighborhood?
any member that pays their annual assessment is allowed to vote.
And you just told me the undeveloped lots, they're still assessed.
Yes.
So if I am DR Horton and I own 80 lots over in phase 2, I'm having to pay a fair amount of annual assessments, but I get to vote 80 votes.
Yes, Your Honor.
Okay. Interesting. All right. So I understand better. Your injury from the mailbox is very different from DR Horton's injury because there wasn't one because they had no mailboxes.
Correct.
Are you aware of any differential treatment of people within phase 1, assuming they didn't send in the little form saying, don't touch my mailbox? So if I did what you did, which is I don't send in the form that says, don't touch my mailbox, would my mailbox have been replaced as well if I was in phase 1?
Yes.
Okay. All right. Thank you.
Okay. Let's see. So then next, let's see, we're talking about the voluntary payment of $50. So the reason why that I paid that under duress was members of the community essentially signed a petition to recall the vote, to recall the board to vote for their removal. And so
This was the board that replaced the board you had been on, or is it later on in time?
later on in time,
Okay.
but this was the summer of 2020.
And by then, is it a completely different board than the one that replaced the board you were on? Or is it some of the same people?
Entirely different board.
Okay, so you got some folks in 2020 and there's a grassroots movement to say, it's not even election time, it's a recall?
Yes,
Okay, so it would be out of cycle vote.
yes.
Okay,
And so one of the changes that were made to the voting rules was that you had to be current on all your assessments. Prior to that, the only requirement was that the only requirement prior to that was that members had to be current on their annual assessment.
Okay.
So as a result of the change in requirements, I paid the $50 assessment.
Because you wanted to be able to vote in the recall election.
That is correct, Your Honor. And I submitted, affidavits to, support the contention that, hey, this was not the rule prior to this particular special meeting.
Do you know, and really what I should ask, is it in evidence, but I'll ask that secondly. Do you know when the rule was changed from you've got to be current on your annual assessments to you've got to have nothing on your balance, no fees or fines?
At the time the notice was sent out for that special election.
That's when it was changed, or that's when you learned it had been changed?
Well, I would say that's when I learned that it would have been changed.
Okay.
Prior to that, I'm not aware of any correspondence sent to the members of the community that requirement.
Letting you know
had
there'd been a change.
Sir, correct.
There hadn't been any. Okay, got it.
Let's see. All right. Let's see. Paragraph. Getting back my place, Your Honor. One moment.
Take your time.
Let's see. All right. Okay. Okay, so going back to the $50 fine. So basically, the fining procedure is outlined in our bylaws, and the letter did not meet those requirements. Without a date, I have no way of knowing when I'll actually be issued a fine if I don't correct the violation. All right. So
that's paragraph 105 of your complaint. You say that the assessment did not meet the requirements of bylaws article 3.20. And if I were to read that article, that's where it would say there needs to be a date
on the correspondence.
On the correspondence. And you got some notice that says, hey, Mr. Skinner, your yard doesn't look like it should. You owe $50. No date on it.
Yes.
Okay. So I'm not, you may be 100% correct technically. I'm curious, when you got the notice, were you sort of scratching your head saying, I don't know what you're talking about because my yard looks great now? Or you appreciated what the concern was and it wasn't, hey, if you had sent this, if you put a date on this so I would know, you thought back in June my yard was bad. It was, but I've since cleaned it up. Here we are in August and my yard looks great. Was your confusion, you weren't sure what it was they were talking about, or you're being technically correct? I'm not saying you're not. That, look, yes, my yard may not look good, but you've got rules, I've got rules. You're supposed to date this thing so that in the future, if we're referring back to it, I can refer to the August 19th fine notice that you sent as opposed to some unknown date. Was my question clear?
Yes. So
I don't want to get in an argument about how great your yard looked. That's not my point. It really isn't. I trust that your yard is super. I don't judge people's yards. Mine doesn't look great. I'm just trying to understand the heartburn about there being no date on it. And one heartburn could be, look, your rules say you're supposed to put a date on it. Could you please follow the rules? Because someday you're in court, we could be fighting about this. And it's kind of hard. Lawyers, judges, people like to be able to say, your August 7th letter, the one that has this date, and doesn't have a date on it. It's just this notice. And someone could say, oh no, we didn't give that to you till November. Is that the concern, or was the concern more, my yard was fine? But by the way, I noticed you didn't put a date on it.
No, my concern was the technical piece of it.
Okay. What was wrong with your yard?
I needed to trim my hedges.
Me too. But I don't have a homeowners association.
All right, let's see. Next, I would like to, let's see. Attorney Moore, he annotated that I generally complains of the 2015 board election. So one thing, they always characterize that my administration was voted out. So I guess you could say we were voted out. The individuals that replaced us were investors, and all three investors took over our three board positions.
Was this because of the power of the block of phase 2? Or were they people who owned just a bunch of lots in phase 1?
They own lots, a block of lots in phase 2.
Okay. So like you were just, if D.R. Horton owns 80 lots, I made that number up, that's a pretty powerful voting block. In fact, that's more votes in that one land holding than everyone in phase 1.
Correct.
Okay.
However, the bylaws state that co-owners can't serve on the board at the same time.
What's a co-owner?
So it's defined in our Declaration of Covenants and Restrictions as owner. An owner is people who live in the same household, managers, agents, and it gives a long list of what is considered an owner.
So someone who owns 80 lots can vote all 80 votes, but they could only be one person on the board.
Correct.
Because it's the same owner of all 80 lots.
Correct.
So what happened at the election?
So at the time of the election, I guess you could say nobody knew that rule.
That's often the case.
And so Century Management assisted with the election. I want to say a couple months later, I just wasn't happy with the board being monopolized. I mean, you had investors essentially buy a block of lots in phase 2, but they wanted to operate in the community as if they were the declarant, and they weren't. They were just basically lot owners like homeowners, but they had, a lot more votes. But they wanted to monopolize the board so they can drive the decisions that's made for the community. So basically, I read everything front to back, and then came across the rule in our bylaws: hey, no co-owners can serve on the board at the same time. So I raised this issue continuously via email, at HOA meetings, even made a petition. I shouldn't say a petition, made a motion that was passed at the HOA meeting to have the board formally address this as to how the makeup of the board did not violate our bylaws. But prior to that, one of the board members from the investor group, and they were actually managers for the investors, stepped down. And so they appointed Darian Watson, who was actually a homeowner in the community.
Who appointed? The board did?
Yes. So our
They
rules.
just randomly pick someone?
Yes. So per our rules, when a member of the board of directors does not finish their term, the remaining board members can appoint somebody.
Okay, so that was legit. You may not be happy with who they picked, but they were free to pick someone, and they happened to pick an individual homeowner rather than another manager from one of the investment companies.
Yes, but I like to characterize a valid board will have the position to be able to, pick, because the three individuals shouldn't have been on there at the same time in the first place. Nevertheless, eventually that set of investors sold their lots, so they no longer had an interest in the community, and so Darian Watson appointed their board members. And this basically took place from late 2016 through our last election, which was January of 2021. So the last election that occurred prior to January 2021 was March of 2015.
why were there no elections is it supposed to be every 6 years that there's an election?
No, it's supposed to be every 2 years.
Every 2 years.
Yes.
So where was the 2017 election?
Supposedly there was not quorum.
Oh, this is what Mr. Moore said, is that you're saying supposedly, but you're saying the same thing, that the story is there wasn't a quorum at that board meeting.
Correct.
Okay.
Correct.
And I
the reason
assume
why
it's the same with 2019?
correct.
Okay.
And the reason why I say supposedly because membership lists were not provided to the community. So I'm not sure why Mr. Moore annotated in their response that I was trying to, disregard 6 prior elections because no elections actually had taken place.
Okay, I heard him say more along the lines of what you said. I don't know that he said supposedly no quorum, but he said, as he understood it, a couple of elections didn't happen because no quorum. But importantly, for his perspective, there was an election in 2021 that reflected the will of the majority of the quorum votes. And so the board that's in place now, it can't be said, oh, this is just appointments made by Darian Watson or investment groups. This would be, I guess, the majority deciding who ought to be on the board. That's what I heard Mr. Moore saying, not that, hey, there've been all these elections, what's the big fuss?
I believe that is what he stated on today's call, but in his
Motion, it was a little, okay.
Yes,
Got it.
yes.
Okay.
However, with the last election there, it is not without controversy.
Okay, you wouldn't be here. It sounds like Oakshire is that maybe like there was an old graveyard there before something. There's a lot of controversy flowing through the bad karma there. I'm sure it's a beautiful neighborhood, but I'm not trick-or-treating there.
Okay, all right. Next, Attorney Moore, he annotates that I'm complaining about the mailboxes being replaced, to provide uniformity, throughout the neighborhood. Well, just the mailboxes had never actually been discussed with the community. I guess you could say formally. There was one informal meeting, and as you know, at an informal meeting, quorum is not required, so it's as if a meeting didn't take place where the mailboxes were discussed. So again, it's not about the uniformity, it's about the non-compliance with our restrictions. He also annotates that the HOA has the ability to require the replacement of mailboxes under certain circumstances. And that would be, for instance, if I didn't service my shrubbery that I received a violation for, eventually, the HOA has then the authority to come onto my lot and to make the correction and bill me for that service.
Mm-hmm.
But again, that didn't happen here. All right, let's see. All right, so then also he, highlights that I didn't return a notice declining the mailbox. Well, Your Honor, there was no real option to decline the mailbox. You either could receive the mailbox from the HOA at the HOA's expense, or you could replace the mailbox at your expense under the conditions that even if the mailbox was replaced at the member's expense, my expense, the HOA will have to approve it. And if you didn't replace your mailbox within 30 days after the other mailboxes were replaced in the community, you would then be fined $100 per week. So at the time I filed for summary judgment, I should have had $50,000 in liens against my property.
Okay. So your point isn't that it was simply you could say no thanks. If you sent back that form that said, please don't get rid of my mailbox, you then incurred a different obligation, which is replace it at your own expense. But if you wanted to have a mailbox that had a Georgia dogs, red and black and white, you couldn't do that if that wasn't consistent with whatever the HOA restrictions were.
Yes, whatever I guess you could say the board would have decided.
Was it the board or their basic guideline? I mean, if you wanted to have a Georgia Tech Yellow Jackets mailbox, who has to bless that?
So
They're a
we-
design committee, or are there guidelines in the bylaws that say no college logos on mailboxes must be black or white or?
So at the time, I believe that the board served as the architectural control committee. It's my understanding now we do have a separate
But
architectural
back then,
control.
it may have been one and the same.
Yes.
Okay.
Let's see. All right. And then, he also, pointed out that, hey, that I benefited from the mailbox. Because, the mailbox was new, but really it's not a material fact here. Like the issue is you took my personal property through a notice that said that you had the authority to do so when you didn't.
It was your personal property because you owned the lot. Was it like a special heirloom mailbox that you had installed, or your point is simply, hey, it's my mailbox and you took my stuff?
Actually, I purchased the home, but I actually had to buy the mailbox separately. So it wasn't like an heirloom, but I had to go down to Home Depot.
But you put blood, and well, hopefully not blood, but sweat and maybe some tears getting it to stand up straight and everything.
That is correct. And that's one of the reasons why the mailboxes were not uniform throughout the neighborhood, is because some homeowners had to install their mailboxes personally.
Got it. And I go to Lowe's, you go to Home Depot, someone else goes to Ace Hardware, and they're all looking different.
Correct. And, he also highlighted today that, there was issues with, people not receiving their mail unsightly. Well, in those instances, first off, if a homeowner is not receiving their mail, that issue is between the homeowner and the United States Postal Service. Right. The HOA doesn't have equities there. And if the mailbox is unsightly, the HOA should be notifying the homeowner, hey, you need to make this correction or else. And that didn't take place either. All right, let's see next. And some of this, Your Honor, will be repetitive as I go through his response.
Well, and you don't need to repeat. I mean, if you want to say, you can present it how you want, but what Mr. Moore did was say, here's my argument, and that applies to counts 1, 5, 7, 8, 3, 2. So you can do it however you want, but I don't need you to, I prefer that you not say count 1, and here's your argument, count 2, and here's your argument. If you can group things, that I think is more effective for all of us.
Okay. I'll do that to the best of my ability.
Okay.
All right, so one of the things he talks about is counts 1, 2, 6, 7, 8, 9, 13, 14, 15, 16, 17, 18, 19, 20, and 24 are
This is the statute of limitations.
Yes.
Yeah.
The declaratory judgment. So here, the issue is when did I guess you could say the harm actually stop?
So I want to make sure we said different things. I said statute of limitations. You said declaratory judgment. And he's made both arguments over a whole bunch of your counts. Are you talking about the statute of limitations, where Mr. Moore is saying, if you, Mr. Skinner, wanted to bring these claims, you needed to bring them within 2 years of the incident? He makes a different argument that covers even more counts, that the relief you're seeking, and you say as much in your complaint, Judge, I want you to declare that the homeowner association action on this date was inconsistent with the bylaws. Which of the two categories are you talking about first?
I would say the latter.
The declaratory judgment.
Yes.
Got it.
Yes.
I'm following you.
Yes, because essentially, he points out that, hey, I'm not looking to, seek to clear up any uncertainty. Well, I mean, that's just completely not true. I mean, numerous times I have tried to clear things up with the HOA, as well as, I guess you could say through the filing of the lawsuit, because I'm asking the court, to make a decision, because the things that I'm alleging here, even though that they have occurred in the past, they continuously will take place because it is a HOA. All right. So one of the things that he talks about is that my claims are mainly derivative in nature and lack the proper standing. So here, the HOA, as we have been discussing, came and took my personal mailbox. And I'm saying that, hey, court, I need you to look at to see if this was legal or not per our rules. In addition to that, now that we're here, if it is, even if it is legal, I'm also alleging that this board doesn't have the authority to do that. And I'm able to raise
That the board back then didn't, or that the board still doesn't? They're two different, because you say this board, and I know there are debates that you've helped me understand about, was that board back then even a valid board because of quorum issues, or what did you call it, co-owners? You can't have two co-owners. Is that what you're talking about? Or it's that no board could do this because the bylaws don't allow it?
Well, I'm actually saying both.
Both,
So,
okay.
yes. And normally, as is, discussed throughout case law, if there's a election irregularity, there has to be a derivative action to address that. But what I'm saying here is because I have the direct, injuries of my mailbox, my records requests, my meeting minutes requests being denied, those are my direct injuries. And I'm also asking the court to now explore, hey, are these people that are on the board, do they have the authority to deny these requests? All right, let's see, next, looking at Dunn versus Cirarelli. And so pretty much the individuals that did, I guess you could say, file a complaint, the reason why they weren't able to do that is because they didn't have any special injuries. The case law went on to discuss that if one of the complainants, if their actual vote was negatively affected by what transpired, then they would have had the ability to bring a suit. But since that didn't happen, they didn't. But again, here, I have stated what my direct injuries are or special injuries are, which are separate from the corporation. Let's see. And it's pretty much the same thing in several of the cases that Attorney Moore cited, like Phoenix Airlines Serve versus Metro Airlines. Again, in that particular case, there was no injuries to the shareholders in their individual capacities. Let's see, Crittenden and Southland Homeowners Association. In this particular case, they failed to demonstrate that they were in need of guidance from the trial court to protect them from uncertainty regarding some future conduct. So when I filed this lawsuit, which was, spring of 2020, one of the things I put in there was the violation of the bylaws as it pertained to the makeup of the board. And at the time of the filing, the subsequent board members who were appointed stemmed from the illegal election. But what I'm trying to demonstrate here is when I'm asking the court for a declaratory judgment, it's because it's very clear that the issues that I have raised in my complaint are due to happen in the immediate future based on however the court rules. So if the court rules that, hey, Mr. Skinner, you can't, we don't agree with you in your complaint, then I'm basically guaranteed harm in the future versus I'm asking the court to, hey, look, the records request was denied in the past. If the court affirms that, hey, there was no violation there, then that basically guarantees that I will be denied records in the future. Because throughout the case, with my complaint, the defendants haven't asserted anything as to address the validity of my claims. It's more or less, I guess you could say, the legalese in layman's terms as to, can I bring this before the court? So I need to, talk about, he said, my accounts primarily apply to the membership at large. And yes, but it's just not that simple. My records requests were denied. Now, if the court says, hey, HOA, you should have granted those records requests, well, obviously, that would benefit the membership, but the fact that it has affected it will affect, other members of the membership based on the court's ruling, it doesn't mean that I didn't have a direct injury. We already discussed the suitable action. Oh, so I need to also clear up. Let's see. Attorney Moore discussed how my claims were adversarial to the general interest of the corporation and shareholders.
That some of them were something like punitive damages, things like that. Not all of them.
Yes, mainly pertaining to the mailboxes.
Mm-hmm.
So what was misconstrued there was I did not or am not petitioning the court to have homeowners who received the mailboxes to reimburse the HOA. What I was explaining to Attorney Moore is per our restrictive covenants, basically the rules state if all members do not benefit from an expense, the expense has to be assessed to the members who received the benefit. We already talked about the number of elections that have been held.
What is your response to Mr. Moore's observation that some of the things you want declared or relief you want would effectively unwind the current election? I know you said this current election was not without controversy, which doesn't surprise me, but that's not one of the claims here, that the current board was illegally constituted. But if any of the relief you're seeking is inconsistent with maintaining the current board, doesn't that undo the majority vote?
I guess in the most simplistic terms, yes.
Okay. Well, what's more complex about it than that?
So the very first count, I'm asking for, declaratory, judgment from the court as to can co-owners serve on the board, or should co-owners have been allowed to serve on the board? And one of the requirements to receiving a declaratory judgment is that you have to show that there's going to be immediate harm or immediate action based off the court ruling. And so in this particular case, we have two members from Silverstone community serving on the board at the same time.
Right now, the board that is currently in place?
Yes.
Okay.
And some of the things that are taking place within the subdivision, because I need to explain the injuries that are taking place is, let me back up a little bit. When Silverstone first came into the community, I want to say roughly 2018, they presented to the community at an informal meeting, hey, these are the types of homes that we plan to build. And it included how the homes looked and the sizes. And they were consistent with what we currently have in phase one. Since then, things have changed a lot. Like currently, the largest floor plan in the villages at Oakshire is 3,100 square feet. Now they're saying that the board has approved homes maxing out at 2,500 square feet. So in most of the homes, off the top of my head, I would say hover around 2,000 square feet, whereas in phase one, we average about 2,700 square feet.
So bigger homes in phase one.
Yes, yes. And in addition to that, the look and feel of the homes that have been approved by the board in phase two have changed. And so what is unique about our subdivision versus other developments is our original declarant went out of business, and a subsequent investor bought a block of homes and let me rephrase that, a block of lots in phase 2 and essentially try to get the HOA disbanded. Well, ultimately the HOA prevailed and the courts affirmed our declaration and covenants. In addition to that, if you pull the deed of the lots that are in phase 2, it's essentially stated that the HOA has exclusive control as to what can be built in phase 2. So now you have co-owners, which is, I guess you could say, fair dealing on a board approving their interests. So co-owners shouldn't be on the board, and also, they're approving their own interests in the subdivision. So those are the current harms taking place. So like, for instance, I received a violation for my bushes. If I was a board member, I should abstain from voting to waive that fee or not. And that's not happening right now with the current board makeup. In addition to that, despite the fact that the rule is homeowners could not participate in the election if they have any assessments on their account, board members, some of the board members from Silverstone did have assessments against their account at the time that they were approved to be on the board. All right, let's see. To address the 2-year statute of limitations, and that's going to be for counts 1, 2, 15, 16, 17, 22, and 24. Let me pull those counts up so I can follow as well. All right, so the breach of bylaws. So the 2-year statute of limitations actually doesn't even apply here because the violation was ongoing. The violation commenced, at the March 2015 board election, but until you have an election to cure that deficiency, the violation persists. And at the time of the filing of this lawsuit, there hadn't been a election to cure that deficiency. Let's see, the misappropriation of funds. So again, here, I asked for a, declaratory judgment because, if the court says, hey, this is okay, then this will continue to take place. And since the filing of this lawsuit, the HOA has used, group funds to clean sidewalks of members in phase 1. So we still have that going on within the subdivision. Let's skip into 15. No board meeting minutes have been produced. So, the request is still essentially outstanding. So here, let's see. One moment. For 16 and 17, I won't address the statute of limitations claim against Century Management. We already have talked about the reason why I'm still requesting an injunction for an election that's count 22. And then, let's see. Oh, and then the open board meetings, those are still not occurring. So it's not like something happened in 2015 and then in the future, the behavior of the HOA changed. All right. We touched on this a little bit.
But let me, so there were a couple that you sort of glossed over. Is that because you're acknowledging, well, maybe there's a statute of limitations argument there, like 17. 17 alleges something about funding maintenance on lots 186 and 187. Doesn't say when that happened. I don't know actually how we would even determine if a statute of limitations had run or not, because there's no date in there.
Well, I know it has exceeded 2 years, but that count is more or
Well, and
less.
it's not 2 years as of today. It would be 2 years when you filed the suit. So if it happened in 2019, you're okay because you filed the suit in 2020. If it happened in 2017, may not be okay because 2020 is 3 years after whatever was done on lots 186 and 187.
It exceeded 2 years
Okay.
prior when the case was filed.
Okay.
And that particular count more or less is speaking to Century Management's role in enabling that.
Okay.
All right, let's see, go to 15. So we touched on this a little bit. Attorney Moore brought up that basically I'm requesting advisory opinions and that are guised as declaratory judgment requests. And essentially here,
Well, I think I understand what your response has been, which is, well, this conduct is continuing. And so it's not that I'm asking you to say what happened in 2015 was good or bad, or was consistent with the bylaws or wasn't. The way I'm understanding you, Mr. Skinner, is this stuff keeps happening. And so I need a court to say that's not consistent with the bylaws so that uncertainty over, well, is it going to happen again is removed.
yes. And I'm trying to also demonstrate to the court that an injury is looming depending on the outcome of the court's ruling. And pretty much that's consistent throughout several of the cases that were cited in Attorney Moore's response to my motion. All right, so I need to highlight. So pretty much, one of the, I guess you could say, tests or standards, or is that when you ask for a declaratory judgment, it can't be just for, academic interest. And,
True.
And I'm trying to clearly convey to the court that, hey, these are like basic HOA things, receiving board meeting minutes, HOA meeting minutes, membership lists, at meetings. All right. All right, let's go on to the $50 yard assessment. So voluntary payment doctrine. So pretty much it says that, voluntary payments, can't be recovered when there is no misplaced confidence, deception, fraud, and made under urgent or immediate necessity. So definitely my, misplaced confidence here, since the community's existence, it has always been, hey, if you're current on your annual assessments, you can vote. But when the board was recalled, to vote for their removal, then those rules changed immediately. And that notice was concurrent with the meeting notice itself. All right. All right, next, moving on to that, pretty much I didn't take any action regarding the mailbox placement. I mean, we have discussed that, hey, you really couldn't decline it. And if you declined the mailbox, there were essentially consequences. Trespass, let's talk about that for a moment, please. Trespass is, according to Georgia law 51-11-2, trespass is not committed if not obtained by fraud and consent free. So, oh yeah, the consent was free of cost. So I've already explained, what the cost was for not consenting, and I'm also alleging that fraud took place because the verbiage in the letter is different from the actual verbiage in the Declaration and Covenants and Restrictions. Given and that was what the HOA cited as their authority to remove the individual mailboxes. And so, just as a additional information, the mailboxes, I don't know what you call them, but you have our front yard, the sidewalk, and then as in width of 12 inches of grass that we as the homeowners, are required to maintain. So I'm asserting that is our actual property. All right, let's see. He also says that, hey, punitive damages are improper here. Well, it's very clear to me that if, the court says, hey, doesn't matter that the mailboxes were taken, we're not going to award any damages, punitive damages, don't apply. In the event that the court, does rule in my favor, in case law, we'll see Lair versus Clipper Petroleum. In rare circumstances where the breach of contract, and here it would be our covenants and restrictions, entails an act of fraud, and I've already, discussed what I'm claiming is the fraud, punitive damages may be imposed. And essentially the whole purpose of punitive damages is to deter the behavior. I mean, because this is a pretty, for me as a homeowner, it's a pretty dangerous precedence because if the HOA has the authority to, compensate property at will, then, where does that leave my rights as a homeowner?
So how do you envision that playing out? Let's say that your mailbox claim persists and then you're awarded damages and the ultimate fact finder, a jury says, yeah, and this was particularly egregious. There was fraud involved, and we want to deter it from happening again. So we assess $500,000 in punitive damages. Where does that money come from?
Well, if that did take place, the HOA has director's liability insurance, and it should come from there.
And if the liability insurance company says, whew, this is not a community we like insuring at the current rates, and so now we're going to raise our premium to $10,000 a year, who ends up paying for that increased premium?
Homeowners. And also, what I would like to add to that is, there's a couple different ways. The court can say, hey, to award judgment to the other members of the community, that will require derivative action. I could be separated, from the other members of the community. In my pleading, I did annotate, plaintiff and, members of the, community. All right. And the goal here is not looking to get a large sum of money like that, but
I didn't ever view this as a get rich quick scheme.
Yes, Your Honor.
Understood. It seems to be much more a matter of principle.
Yes, Your Honor. It's just let's say that, the scenario played out in, my favor and punitive damages were awarded, and let's just say to everyone, if it was $5, it still sends the message that, hey, the HOA did do something wrong.
Sure. And they should not do it again.
Yes. Oh, okay. And so another element of punitive damages is that it can't just be for, simple negligence or even gross negligence. It has to cross like a certain threshold. And here, I'm asserting that it has crossed that threshold. I mean, between two law firms, the law firm of the opposing counsel, as well as the routine law firm that assists the HOA in these matters, as well as the board members and a management company, nobody has provided an explanation as to why the verbiage in the letter differed from the actual declaration of covenants and restrictions. And I can say for certain that the law firm that the HOA retains is, they're familiar with, HOA law in layman's terms. So I'm confident that they should have been or had an awareness, somebody had an awareness that, hey, when you add the word lots, to that letter, it's going to change the meaning and, essentially present to homeowners differently than what it presents in the Declaration of Covenants. All right, I'm almost done. Let's see. So, and I talk about this in the complaint, and then we have talked about this, I want to say during the depositions, we have informal meetings, and that started after, my administration. And, if it's an informal meeting, essentially is not a meeting because no business can transpire because there's no requirement of quorum. And in discovery, nothing was presented to support that, the mailbox initiative was, presented to homeowners for to make a decision to vote on. So essentially, that has to speak to that this was simply a board's decision. And let's see. And in case law, let's see, Hall versus Town Creek, and also McGee versus Patterson, two main points that they make is that decisions of boards cannot be arbitrary. And I would like to emphasize, I have requested board meeting minutes, to support this action, and none have been produced. Also, improper elections can strip acting board members of their authority to act. So, the courts do recognize that, when an election is improper, authority, is stripped of the board members. And that concludes my response to Attorney Moore, Your Honor.
Okay, why don't we shift then? You filed a motion for summary judgment covering, it's like maybe 9 of your counts. It sounds like your argument from it doesn't sound like, in reading your pleading, it's very similar to what you've just said as to why you disagree with Mr. Moore. So I don't need you to repeat the things you just said, but if there are aspects of your claims in your motion for summary judgment that you want to share with me, now is the time to do it. If they are separate and distinct from what we were just talking about.
Okay. Can I just take one moment?
Sure.
Okay. No, Your Honor. As you have explained, you have read what we wrote, so I will adhere to your guidance. I don't have anything additional to add.
Okay. Mr. Moore, anything you want to add in response to Mr. Skinner's motion for partial summary judgment that you haven't already covered, A, today in your oral presentation, or B, in your response to his motion for partial summary judgment?
A few things, just a few bits and pieces to point out. So his response to, or our response to plaintiff's motion for summary judgment is essentially very similar to what we talked about. He makes some admissions that go along with the arguments I made for my motion. In his motion, on page 2 of his brief, he says that the election issues stem from biannual elections in 2015 and 2016 for the board of directors. Goes to my statute of limitations argument. He believes that all of the other votes since that time are invalid and the court should essentially disregard them. That goes along with what I mentioned earlier. Kind of touching back on that mailbox issue, to reframe it, in pages 2 and 10 of his brief, he does say, quote, no authority exists in the HOA's declaration of covenants, restrictions, and bylaws to carry out this act. This act, or ellipsis, this act suggests to the plaintiff the HOA's authority within the subdivision is without scope. Again, demonstrating the basis of that argument is a violation of covenants, which is that applies to every member of the association. Because again, like I mentioned earlier, the case law doesn't say that. We're not saying that Mr. Skinner is not affected by a decision. That's not enough to get you past derivative versus direct. You have to articulate that the basis of your claim is distinct. The basis of that mailbox argument is distinct. And essentially, Mr. Skinner's motion is simply, it looks like he's asking the court to foreclose on the requests for declaratory judgment. I won't rehash all that issue again for you. One thing I would point out, though, is that because in his motion, he is the movement. He has the burden to demonstrate the lack of a disputed material fact. And he doesn't provide any admissible evidence for those ends. I mean, his brief talks about imminent danger of infringement of a valuable right, but he never demonstrates that fact with evidence anywhere. He says them, he articulates a conclusory statement to it, but his evidence is lacking in the motion. So like, here's another example of the declaration issue. He's asking for this $50 fine to be given to be, I guess at this point, not to be stricken from the books, but to be refunded to. But he's asking for the court to declare that that was wrong, but at the same time, that's already taken place, and I guess he just wants to know if that was right or wrong for his own benefit. There's really no future, there's no future-looking portion of that argument. I don't think I mentioned it too much in my original argument because it was it goes to the theory, the relief he's seeking, but he's asking for injunctive relief repeatedly, and that's insufficient and lacks evidence. This court's well aware this is Superior Court. We all get requests for injunctive relief all the time, and injunctive relief is an extraordinary and drastic remedy that is never awarded as a right. I can cite you the cases, but I'm sure you know them. An injunction is an equitable remedy. It should only be granted when there's clear and urgent need and no adequate remedy at law. So similar in that vein to his request for declaratory judgment, he's presented no admissible evidence that would demonstrate a clear and urgent need that would warrant injunctive relief. In fact, the case has been pending for over a year when plaintiff first requested injunctive relief, right off the bat. Certainly, if plaintiff was in clear and urgent need of an injunction, he would not have waited a year to do anything. Importantly, the harms he asks for in his motion for summary judgment are nothing more than conclusory complaints about the past. We talked about the $50 landscaping fund that he's already paid and doesn't dispute the basis of. He also asked for injunctive relief referencing the mailbox replacement in the neighborhood that occurred in 2019, but does not articulate what he's asking the court to do injunctively. He argues that the court should issue an injunction with relation to the 2015 election, but also admits that there have been other elections since that time and none of the individuals referenced are still serving. None of these contentions show clear and urgent need. That's kind of the point. Failing to show that there's no adequate remedy at law. That's another essential element of injunctive relief. Asking the court to remove the $50 fines, essentially requesting he be reimbursed $50. That's a legal remedy. That's a money damage. That's not an exercise of equitable power. That's just a award of damage. Here's your $50 back. Another issue is the mailbox replacement. So even though that issue gets a little sticky because he says, yes, on one hand, they came and took my mailbox. But on the other hand, he does admit that he got a more valuable mailbox in return. There's a question there as to whether there's even a claim of damages in any event. But again, we're talking about the value of an item lost. That was over 2 years ago. The only remedy is a legal remedy at this point. So there are legal remedies at law, and he can't ask for injunctive relief for everything, even if he's essentially just asking for a money judgment. So I think it's somewhat similar to the declaratory judgment argument in that there's not sufficient evidence for that. I would point and direct the court to review plaintiff's statement of undisputed facts that are included with their motion for some or partial summary judgment. The face of their motion says summary judgment, but their brief says partial summary judgment. So I believe we're construing this properly, that it is partial. But the statement of undisputed facts contain no citations to the record, are conclusory, and even if were true, would not establish the relief. His conjecture is not enough to sustain a motion for summary judgment, particularly when you're asking for injunctive. In fact, other than what Mr. Skinner copied from my statement of facts, his statements don't contain any citations at all. I pointed out in my brief that only two of the contentions in his statement of undisputed facts he made, and they simply say that he has been attempting for years to resolve the issues with the HOA to no avail, and that he suffered special damages. Those are just conclusory statements. I understand Mr. Skinner is not a trained attorney, but he is pro se, and that doesn't give him access to any other legal or procedural standards. So as such, I think his motion for summary judgment should be denied. One other principle I want to share, just because I think it's helpful in analyzing cases like this, is a case called Waller versus Golden. That's 288 Georgia 595. It's a 2011 Georgia Supreme Court case. So there's a principle in that case that I think may help on some of these issues. So in that case, it involved the Eagles Landing Country Club community. So let's just say neighbor number one wanted to build a pool. They asked the architectural committee for approval. Architectural committee said yes. They paid money, started having it built. One of the neighbors next door said, hey, you can't build that. That's against the covenant. The architectural committee should have never done it. There's a big uproar in the community. I think there was a meeting held over it. Grievances were filed by everybody, belly aching about this pool, because once they went back and looked, they were right. That was a violation of the covenant to approve of that. An architectural committee shouldn't have done it. But the HOA was in a unique position of having to deal with, well, either we tell them now, even though they've invested all this money in the pool and they've relied to their detriment at this point on our representation, they could do it. Either we face a lawsuit from them for the damages they've incurred, or we upset the community. So the best solution they could come up with was, well, why don't we use association funds to build or to plant a landscaping design around their corner lot to obscure the view of their pool from the road. They planted trees and bushes, so you couldn't see it anymore, to try to lessen the effect and help the overall appearance. Well, as you can imagine, because it's a Supreme Court, there was a lawsuit filed, said doesn't matter, it was in violation of covenants. The interesting thing about this was the allegation was that the association misused those funds to obscure the view of the pool, and that was not a benefit to all in the community. Now, you've probably heard that principle talked about in some of Mr. Skinner's complaints. He talks about that with the maintenance on the lots 186 and 187. He talks about that with the mailboxes, because he makes the point that some lots didn't even have mailboxes, so it didn't inure to the benefit of everyone. So most relevant is the trial court dismissed the claims against the board. They reasoned that because the covenants delegate decision-making authority to the homeowners association, and the homeowners association acted, the only judiciable issue is whether the exercise of the authority was procedurally fair and reasonable, and whether the substantive decision was made in good faith and is reasonable and not arbitrary. So you see this vein in a lot of different corporate cases in terms of it's not the court's role to get involved in the wisdom of decision-making of some of these corporations. That would end in a messy effect. So as long as essentially, yeah, technically sometimes there are violations. Everyone does. Mr. Skinner did. He didn't cut his bushes. Everyone. It's impossible to expect a board of volunteers to take everything to the exact letter that Mr. Skinner is talking about. But they're doing these things in good faith. So the landscaping we talked about earlier, this is a perfect analogy here. The landscaping he talks about on lots 186 and 187, that directly benefits two lots, but it also benefits the community because that was in furtherance of the appearance of the community. So in this case, the power for decision-making is delegated to the board by the governing documents. And as long as they are acting in furtherance of that goal of helping, the neighborhood look better, to make the neighborhood in conformity to protect the values of the properties, those are just the general goals that they're trying to achieve. And if they're acting in furtherance of those goals, it's really not. It's really what I'm trying to boil that down to is because they act on certain lots differently than others doesn't mean that they're acting outside of their scope of their authority. They're just doing this to show that we are caring about the aesthetics, we want the aesthetics, and everyone benefits from that. And that getting involved in the corporate affairs and wisdom of decision making is never a smart move. So I just brought that up in case that applies to some of the things we've talked about today. But principally, I think the case should be mostly dismissed on the derivative action issues and the consent for the voluntary payment doctrine on count 5. Anything else I would say would be a complete rehash.
All right. Mr. Skinner, anything more from you? I think Mr. Moore's had a chance to respond both to your thoughts about his motion as well as your motion. Anything more you want to get before me?
Yes, I'd just like to let you know the responses.
Sure.
So
his microphone's off again, sorry.
Oh, it's back.
So I'd just like to respond just to some Attorney Moore's, closing comments. So when I filed the original complaint, I filed it in chronological order, but I would just like to again emphasize to the court the basis stems from the injuries of my mailbox, the denial of my personal records request. And then because we're there, hey, does this particular board have the authority to act on it? All right. So then we also talked about, well, Attorney Moore, talked about, imminent danger. And I get that that's the legal language used, but I would like or request that the court looks at what does imminent danger mean in the context of an HOA. All right. As it pertains to the value in the mailbox, hey, it's a deposition. You're supposed to be honest. Okay. It's reasonable to conclude that a new mailbox is worth more than an old, unless you have something very elaborate. However, the value is not what's being contested here. All right. We talked about citations a little bit. I'm not sure if
Citations.
he not being in some of my, I guess, responses.
Oh, yeah. Your statement of undisputed facts. That's what he was talking about.
The lack of citations, or I cited it wrong.
What I heard him say is that in your statement of undisputed facts, you say, here's some undisputed facts, but you don't tie them to anything in the record. You say it was hot that day, but then you don't show where in the record there is evidence that it was hot that day, and that's undisputed.
Copy. Yes, Your Honor. All right. I'll also like to, point out with the example pertaining to the Eagle Landings community. I believe I heard, Attorney Moore expressing that, hey, this issue, regardless if it was against the rules, it was at least formally discussed with the members of the community. That didn't take place here. And he also goes on to talk about how these are volunteers. But despite that these are volunteers in Georgia, a HOA can foreclose on a home for $2,000 in assessments. And, actions or inactions of boards can affect property values.
Mhm.
So despite the fact they are volunteers, we still do have responsibilities. And I would also like to add here is when I have contacted the board, the management company in the past, I do provide supporting documentation. And pretty much it just comes back as, well, this is our position without, supporting documentation. And then he also talked about, making the neighborhood look better. I can tell you since this lawsuit has been, filed, our front entrance is the best it's ever looked. We got weed control now. It appears that it's being serviced every week. So prior to the lawsuit, we didn't get weekly, landscaping services. And, it has been communicated to the community, hey, we don't have the money. We can't afford it. But somehow we came up with $25,000 to replace mailboxes. And as I stated before, there's nothing in the record to show that this was even discussed before the community and that this was simply just a decision or a want from the board, carried out by the board.
Mhm.
And that is all I have, Your Honor.
Got it. Well, you have both given me a lot to think about. I appreciate that. What I will do is take this under advisement. And either I will draft an order, or I may, depending on what I think about the arguments and the relevant case law, let you both know, Mr. Moore and Mr. Skinner, what I think the right answer is, but then I will draft one of you to draft the order, and it would be the side that's prevailing. So if Mr. Skinner, I think you should be granted summary judgment as to your claims, I may say, and please draft the order to that effect. It'll be a draft. It would be subject to editorial comment from the other side. It wouldn't be a chance to say, no, wait, Judge, you decided this the wrong way, so change your mind. It would simply be, you know what, I don't think that's what the record shows. So I would consider the comments, but ultimately I'd make the order my own. But it may be that I decide to draft the order. I may farm it out to whichever side I think is prevailing, or I'll keep it in-house, and we will go from there. Mr. Skinner, anything else on your behalf?
No, Your Honor. Thank you for your time.
You're welcome. Mr. Moore?
No, Judge, nothing here, and I appreciate the opportunity.
Okay. Well, we are at a close for today then. It's 4:35. I hope everyone has a good rest of their Wednesday, the little bit that's left of it. And Ms. Niles, my staff attorney, will be in touch with both sides soon. Okay?
All right, thank you.
Thanks so much. Oh, and make sure you all take care of Ms. Allen. I don't know who line
Yeah,
Ms.
I hired her.
Great. You'll take care of her.